Good afternoon, Your Honors. May it please the Court. Alexander Strassman on behalf of the appellant Dana Loyd. Your Honors, I'd like to reserve 3 minutes for rebuttal instead of the 5. Your Honors, we ask that this Court reverse Ms. Loyd's conviction and remand this matter for a new trial on the grounds that she was denied her right to a fair trial for 3 reasons. 1, because the trial court abused its discretion in admitting 3 instances of Williams Rule evidence. 2nd, because the trial court departed from neutrality and misled the jury with its improper comments.
What are the elements of the offense?
The elements of the offense, Your Honor, are that first, there has to be a false report that was made. 2, it has to be with the intent to harass or embarrass. And 3rd, that it can't be done in good faith, because if it's done in good faith, it's not with the...
If what you are characterizing as Williams Rule evidence is relevant to any of those issues, that characterization of as Williams Rule would really be inaccurate, wouldn't it?
I disagree, Your Honor, respectfully. I would say that it would go directly to intent, which is what the state actually says in its appellate brief, that this evidence was, the 3 instances of what we're calling Williams Rule evidence was probative for that purpose, for proving the intent to harass or embarrass, and that's what the trial court held below, that it was Williams Rule evidence. And are we
bound by the lower court's characterization?
No, of course not, Your Honor, but I would point out that as part of the record, when Ms. Loyd was arrested, on her arrest warrant on the record, page 69, there were 2 charges that were contained there. 1 was the false report charge, and 2nd was stalking, contrary to Florida Statute 784.048. And that charge was eventually not, it was no action, it was not filed. But these 3 issues, these 3 instances of Williams Rule evidence were hanging out there, and that's why there was a defense motion in limine to exclude the 3 instances. The trial court held that the door had been opened by virtue of a question that was asked on cross-examination, but it's our position that the door was not opened. And
you say it was relevant because the argument was it was relevant because it showed intent, and that's what made it Williams Rule evidence?
Correct.
Wouldn't relevant evidence of intent, in fact, not be Williams Rule evidence, but simply evidence going to an element of the crime?
Well, as the state said below, this evidence, in their view, it showed a pattern of harassment. So although the false call itself, this was the only instance where a false call was made, there's an argument to be made that the 3 instances where she called the soccer club and this instance, and where she called the Titusville Police Department, all of them show this pattern. Again, it sounds like the state's argument, but that's what they argued below. It shows a pattern of harassment by the defendant. And
shows a lack of good faith on your client's part. I mean, as I understand, she's never met the defendant or the daughter, and she's making these reports, and your defense below was not that you didn't make the report, or that it wasn't, that was done in good faith to stop a molester, in essence.
Absolutely.
Well, but I mean, these other, I'm calling Colorado, I'm calling the soccer coach with claims of this guy, isn't that go to show a lack of good faith, which is part of the defense? And so it's relevant, not as Williams Rule evidence, it's actually relevant to the actual charge itself?
Well, it's relevant for both, right? It's relevant on many different levels for the reasons I've said. But also, I would point out that the evidence...
And if it's not Williams Rule evidence, whether the door was open or not, if it's not Williams Rule evidence, then there's no door to be opened or closed, right?
I understand Your Honor's position. It's our position that statement, those 3 instances were Williams Rule evidence and were properly deemed to be.
I don't know if it's a position I have. It's just a concern that I have. I mean, that's why we're talking here today.
Understood. And the reason why I've said it, but the reason why we say it's Williams Rule evidence is because it does show, it could be argued, that pattern and that it's linked in that sense. The state argues that
And wouldn't it be more traditional Williams rule evidence if she did this to other people and they wanted to bring that she does this to other people as well and therefore she must have done it here with no, I mean, that would be more traditional Williams rule evidence, wouldn't it?
It certainly would, but in this, it happens to be the same individual in this context, Judge. But it is, in all three instances, a false relay of information about the same person. All three of them are talking about the same thing, which is, in this case, it happens to be the offense was a false report to the child abuse hotline, but it's all it's all the same kind of act every single time. All four of them are similar in that sense. The state argues that in their brief that the evidence was also inextricably linked with the offense, and for that reason it was not Williams rule evidence. But it's our position that it's sort of logically inconsistent to say that it was necessary for the state to have this evidence in order to prove up its case when the state didn't even file below any kind of opposition to the three motions in limine. And when it came to proving intent, the state says that it's necessary to prove intent. The state already had evidence that it could use to prove intent. And that evidence...
Is that, so the standard is if you've already got evidence, you're not going to be allowed to put other evidence in?
Not at all, but the issue is whether or not it was necessary. Of course, it was useful, it was probative, it could help, but it wasn't necessary for the state to have this evidence, and that's why they were prepared to go forward with their case without it. In fact, an opening statement, when it came to trying to show what the evidence would, saying what the evidence would show in order to prove intent, this is on the transcript, page 501, quote, this is the prosecutor, an opening statement, and she also attempted to lie about it to Agent Fisher. And when he finally confronted her with the evidence, her consciousness of guilt comes out when she says, "I'm sorry for what I did. I'm not going to make any excuses." That's just one example of how the state already had at its disposal the evidence that they needed in order to prove up intent.
What was the question asked by defense counsel which supposedly opened the door?
The question was on cross-examination to the alleged victim on page 754 of the record, isn't it true that there had been such allegations before this incident that were completely unrelated to Ms. Loyd?
And how was that question relevant to any of the issues in the case? Or why was that question more relevant than the questions that were asked when the door was allegedly opened?
So it was relevant because the alleged victim had testified that he was surprised and that he was embarrassed when this allegation came out. And defense counsel was going to get at the fact that, in fact, this was not the first time. Ms. Loyd's report was not the first time that this kind of allegation had been made.
Yeah, but doesn't that reference the fact that, was it a former wife or was he married to the woman that had with whom he had a child?
His ex-wife.
Ex-wife. So wasn't that actually pointing, she was the one that made the prior accusation, correct?
She was one of them, yes, Judge.
And there are some indications that your client and that woman had some connection, correct?
Well,
wouldn't that have opened the door to that entire string of testimony?
No, respectfully. The reason why is because, and again, it's not binding precedent on this court, but in Red v. State, 49 Southern 3rd 329, Florida 1st District Court of Appeal in 2010, the mere fact that it's be characterized as misleading is not enough to open the door. I concede that it could be argued that there's more to be said about this line of questioning, that it could be said to be misleading, but that alone doesn't open the door. The state needs to have a legitimate need to rely on that kind of evidence, and here they didn't have it. Instead, they just said it shows a pattern of harassment by the defendant. That's why it opens the door.
Take a couple minutes and talk about the judge's statement that good faith wasn't relevant. Do you think the jury instruction, and really what I want to get to is, do you think the jury instruction cures that? And if not, why not?
I do believe that the jury instruction that was ultimately given was sufficient in this case. The problem is what the judge said during the middle of trial.
I get that. And what I'm trying to ask is, why doesn't the the jury instruction that cures that comment, that makes this, tells the jury, that what the judge had said, that's not right, that these are the instructions that you must follow to decide this case. And it sets out that is, in fact, an issue that needs to be determined. Why doesn't that jury instruction cure what the trial judge had said earlier in the trial?
For several reasons. One, it was not given within the context of a curative instruction. It was given within the context of the final instructions that are given to the jury, along with all of the other instructions that are given along to the jury.
Was there any request for a curative instruction, or was the only request the motion for mistrial?
Right. There was no request for a curative instruction, and there was only a motion for mistrial that was not opposed by the state.
Well, they didn't take any position on it.
Right.
It's not like it wasn't opposed.
Not unopposed.
No,
Right.
they just took no position on it,
Right.
which isn't the same as saying we don't oppose this.
Right. No. I agree with the distinction, Your Honor. What I would point out, though, is that there's also a difference, going back to your question, Judge Cohen, is there's also a difference between a comment made like that in the middle of trial and a comment that's made among all of the other comments that are made, all the other instructions that are made at the end of trial. This one really stood out. It was while the defendant was on the stand, and it went right to the heart of her theory of defense, which was her good faith.
But then the jury is told unequivocally that this is an element that the state needs to prove, and the state didn't back away from that in any fashion in their closing argument.
The statements are inconsistent with one another. The statement that were the instructions given to the jury and the statement that was made in the middle of trial.
We expect the jury to follow the instructions that they're given. And the instructions said the state must prove the following elements in order to convict. And one of those elements was, the element of good faith.
Yeah, understood, Your Honors. In addition, though, to being misleading, it was also a departure from neutrality, the role of a neutral judge.
If that's not preserved, then we have the issue of, in essence, the judge, in your view, made a misstatement of the law during the course, near the end of the trial. There was no request for the judge to correct that at that point. There's a mistrial that was denied, and then not long thereafter, in closing, either before or after closing, she gave the correct instruction, and the jury was sent back with that task to decide whether essentially there was good faith here. And okay, they chose against your client, and there's certainly evidence to support that. So what's the problem here?
If it's not misleading, excuse me, if the issue was not properly preserved, then yes, the question as to whether or not it was misleading is the only issue that is before the court right now. We contend that it was properly preserved. As defense counsel said at sidebar, at the transcript, page 846 through 47, defense counsel said to the judge, the court is making opinions about the case and basically telling the jury that she's guilty. And I'm asking for a mistrial. There's no way to unring that bell. The defense counsel didn't use the words departure from neutrality, but it's clear that that's exactly what defense counsel was telling the trial court, that the judge had just basically summed up to the jury what the case was about. Right. And
you're into your rebuttal if you'd like to save some of that.
No, Your Honors, I'd like to, at this point, reserve the remaining time for rebuttal. Thank you.
All right.
Good afternoon, Andrea Totten on behalf of the state. May it please the court, I would like to first address the alleged Williams rule evidence. First, I'm compelled to point out that there is nothing in the record to support the contention that the trial court ever deemed the evidence that we're talking about here to be Williams rule evidence.
Really? Because it looked to me like that's absolutely what the trial judge did. There are motions in limine, and the judge grants the motion in limine. And the motion in limine is to prevent the admission into evidence of these what they called unrelated bad acts. Isn't that the definition of Williams rule?
Well, Your Honor, respectfully, we do have the motions themselves in the record and a short court order that was apparently entered in open court saying motions granted, but we don't know specifically what occurred at the hearing on the motion in limine because that has not been transcribed and provided here today.
The
So
motions, we have the motions.
we do have the motions,
right?
yes.
How would you have characterized, if not Williams' role, how would you have characterized those motions?
The state's position is that it's direct, relevant
I understand your
evidence.
position, but you're suggesting that it was never considered as Williams' role evidence, and I don't think that the record supports that. I think absolutely this trial judge considered that Williams' role evidence. I think the state attorney considered it Williams' role evidence.
Your Honor, again, our position is that without having the transcript from the motion in limine hearing, that simply can't be determined. The trial judge may simply have said, at this point, I don't see how this is relevant. I may revisit that ruling. We don't have the transcript. Appellant has the burden of providing that sort of evidence for this court to consider, but we don't have it, and we don't know what precisely was said during that hearing. Again, the state's position is that
Did the state oppose the motions in limine?
presumably the state did, although opposing counsel points out that the state never filed a written response to the motion in limine. We do know from the record that there was a hearing, but again, appellant has not caused that to be transcribed. Obviously, the state had an interest in introducing that evidence since the state, again, sought to and successfully did introduce it at trial.
Only after they thought that the door was open. They didn't try to do it before the opening of the door. Wasn't that the posture at the trial level?
That's correct, Your Honor, because the motion in limine, on whatever basis it was granted, had been granted up to that point.
How would you have characterized the motion in limine itself? The written motion in limine, how would you have characterized that? What did you think it did?
I would agree with Your Honor that the defense's position seemed to be that they construed this evidence as Williams' rule evidence, and that was
Against that motion in limine, I mean, it seems to me that the trial judge thought it was Williams' rule as well.
Well, Your Honor, the state disagrees respectfully because we don't have a transcript to support that contention. We know that it was granted on some basis that I'm sure was argued at the hearing, but we don't know precisely what was said. Again, the state's position is that it was evidence of especially false report. And
Well, they're arguing that this is Williams' rule evidence that improperly came in. Now you're telling us, well, we don't even know if there's Williams' rule evidence. Why wouldn't it behoove you to get the transcript of the hearing and say, hey, that's not what was argued at all below, and now we're going down a different rat hole here?
well, Your Honor, again, it's the appellant's burden to provide a record on appeal, and they are in the position of arguing that this is Williams' rule evidence that came in.
Seems like, and you're saying, oh, they can't be Williams' rule. We don't know if it's Williams' rule or not. And your position here in issue 2, it's not Williams' rule evidence.
Correct.
And if that's what the judge said below, that would be helpful to you to supplement the record, wouldn't it? Seems like it to me, at least. Go ahead. You on something else here.
Thank you, Your Honor. Again, the state's position is this is just direct evidence of the element of false report. In this context, false report is defined in Chapter 39 as harassing, embarrassing, or harming. And because that's the definition of false report that was given to the jury, the state was required to prove that the defendant harassed, embarrassed, or harmed. There are 3 other potential ways to fulfill that false report definition that are not relevant here. So the state was required, in order to prove this crime, to show embarrassing, harassing, harm. The defendant's phone call to the soccer club and the defendant's phone call to the victim's potential future employer in Colorado are simply direct evidence of that element, in addition to being inextricably intertwined. The state is entitled to paint a picture.
Why was it inextricably intertwined?
Your Honor, the state is entitled to give the entire context of the events leading up to the crime and what was really going on here. The defense was attempting to, immediately before this evidence ultimately did come in, create a suggestion that the defendant was simply one of many concerned citizens who had reported the victim to Department of Children and Families or to the police.
Only we had that transcript of that in limine hearing, we could have heard that inextricably intertwined argument by the state below.
Well, Your Honor, as I argued in my answer brief, even if we take as fact that the trial court originally found this to be inadmissible Williams rule evidence, the developments at trial clearly caused the court to rethink that evidentiary ruling.
The open the door argument, is that what you're suggesting?
That was what the trial court held, that
I realize that's what the trial court held, and we'll get to some other things that the trial judge did in this case in just a second, but do you think that that question opened the door to anything other than perhaps the fact that it was the ex-wife that had reported him and any evidence that the state might have had that linked the defendant in this case to the ex-wife?
Your Honor, yes. There was that question, and then about 2 pages later in the transcript, these are at pages 754 and 756, defense counsel asked 2 questions that were intended, the state's position is that it were intended to mislead the jury. One was the question we just talked about, asking the victim whether there were prior allegations completely unrelated to the defendant, again, creating an impression that she was just one of many people who had reported him. And then 2, a couple pages later, he asks whether, other than the one email that the defendant sent to the victim, whether the victim had any other contact with the defendant. Well, this too is misleading because, sure, they didn't talk on the phone and exchange Facebook messages, but he, in a roundabout way, had plenty of contact with the defendant because the defendant is publishing articles about him. The defendant is calling the soccer club and accusing him of being a child abuser there. The defendant is calling a potential employer in Colorado and accusing him of being a child abuser there. So that question seems designed to make it look like this one report to DCF was this one-time isolated incident without acknowledging the big picture here, that the defendant had been actually taking various actions and harassing for years.
The charge that the state brought was based upon the report to DCF, not based upon the blogs that were written, correct?
That is correct, Your Honor. But again, the state's position is that, like the evidence we've been discussing up to this point, is evidence of, one, a lack of good faith, but also the false report, the harassing, intent to harm, and the embarrassment. The one phone call, if it was genuinely misguided, may not have risen to that level. But when you look at this entire pattern of how she had been harassing this man in the years leading up to this point, including the one previous call to DCF, which came in through the defendant's testimony that occurred in 2014, that's all relevant to the false report, which the state was required to prove.
How can the state get around the judge's comment that good faith isn't important in this case?
Your Honor, first, I'd like to be really clear about what the judge did say, because good faith, she didn't actually use those words. She said, "This is not a case of whether or not your client believed that there was some form of injustice occurring or some bad act occurring. The question for the jury is whether or not there was a false allegation of child abuse made, period, end of story. Whether your client believes she was doing it..."
That's not true, is it?
Because there was a false allegation, but whether it was done in good faith or not was the crux of their case, wasn't it?
Yes, and I would agree that this is not obviously a full correct jury instruction. It doesn't get to the instruction on good faith, which is given to the jury in the context of jury instructions an hour later.
Well,
So
it's
not
more than not full correct. It's, in fact, flat incorrect, right?
Your Honor, I would agree that it's incomplete, but it is not entirely incorrect because, again, okay, the question for the jury is whether or not there was a false allegation of child abuse made. That actually is the sole element.
And she
of
just said,
the-
then that's all we're taught, that's all this case is about, which categorically it wasn't.
Well, you do need to add into that then, which the jury was later instructed on, what it means to be a false report.
It wasn't end of story, period, like the judge said, right?
Right, exactly. I concede that it's not a
That's a
full.
false statement. That's not an incompleteness. That's an actual misstatement, right?
I would respectfully disagree. I think that's a correct partial statement. It does not acknowledge the additional instruction on, well, what does false report mean in this context, and what the defense of good faith means. It doesn't go that far. So it's unquestionably incomplete. But
So ironically, the judge is giving a false statement in a false report case.
I would respectfully disagree with that characterization, Your Honor.
Let
But
me shift you to another issue, and that is the arguments about the closing statement, that the state made two statements, the first one being the only person that lied about everything in this case was the defendant. And the second one was that she lied to the jury throughout this entire process, and the evidence proves that. What were the alleged lies to the jury? I understand the first one in the context of her call had false statement in it. She lied to the police when she first denied that she made the call. But what's the reference in the closing to she lied to the jury throughout the entire process, making reference to?
Your Honor, I assume, having obviously only the transcript as the court does as well, that that was a reference to the defendant's testimony that she believed she was acting in good faith. Her conduct over the years leading up to this actual crime suggest otherwise. The constant writing online articles about the victim, the contacting various people that have no way of helping the child, by the way. If it's true that her concern is for this child, calling a potential employer in Colorado to sabotage the victim's future doesn't do anything to assist that child. So I'm assuming that that reference is to that sort of testimony, that she really was only acting out of concern for the child.
And is it proper for the state to label the defendant as a liar in the closing argument?
There are instances where it's allowed. Maybe there could be argument made about whether it's a good strategy, but there certainly has been recognition that this is allowed. I would cite the Craig case out of the Florida Supreme Court, which I referenced in my answer brief. And this
Admitted lying, didn't she?
Yes, Your Honor, she did admit lying. She admitted that she
She
was
said she
not.
was a school teacher and overheard these things, neither of which were true, and she...
Exactly.
So that's a lie, so you can call her a liar for doing that, right?
Exactly, and she never alleged that the things that she said the victim did even occurred, or at least didn't occur in the 6 years leading up to her making those accusations.
Do you think that I'm going to get back to the prior issue. Do you think that the jury instruction cures the judge's, what you call incomplete, and what others might term inaccurate comment to the jury?
I believe that it does, Your Honor. It was a short time later. This all occurred in the redirect of the defendant right at the very end of the trial, and the jury got the full instruction as it's supposed to be given, and the comment was directed at defense counsel, not to the jury. They simply overheard a little snippet of a conversation between the defense counsel and the judge, and they moved on.
All right, your time is up, counsel.
Thank you.
Stripped of its legalese, this comment by the judge in the middle of trial showed the jury exactly what the judge thought about this case, and that there was no defense of good faith in this case. Period. End of story. That is very different. What the judge thinks, dropping that neutrality, that cold impartiality that the defendant is entitled to, and then during the legalese of all of the instructions going on, one right after the other.
Well, you call that legalese. First of all, typically the jury's given a copy of it, but they're given instructions on the law, and the instruction, and particularly you can't just say, oh, well, you know, they gave all these myriad instructions. There were instructions specifically as to what the state needs to prove in order for you to return a verdict of guilty in this case. And those are called the elements of the offense, and they are set out very clearly to the jury.
But it's not just about the law, it's what the judge thought, and what the judge thought about the defense's case. And this court held in Johnson v. State, 114 Southern 3rd, especially in a criminal prosecution, that the trial court should take great care not to intimate to the jury the court's opinion as to the weight, character, or credibility of any evidence adduced. And that's exactly what happened here. Thank you.
Well argued case.